The Supreme Court will now consider whether a state can put in place a Second Amendment Preservation Act with the purpose of making a state a two-way sanctuary. But the Trump administration is now asking for more time to consider how they want to handle this Second Amendment case and all of these issues. Now, really quick before we jump into this video, I want to ask you guys for a favor. Looking at some of my analytics, about 58 to 60% of all viewers are actually not subscribed to the channel. So if you want to support the channel for free, please consider subscribing. And then also just leave a positive comment down below, because that helps to tell the algorithm that you appreciate this type of content and it should share it to more people. Now, in this video, we're going to be talking about a very significant Second Amendment case that is once again back in front of the Supreme Court. The case is dealing with the state's Second Amendment Preservation Act, and this one specifically is out of the state of Missouri. We've discussed this case before because recently the Supreme Court issued an order denying a stay which would have protected Missouri's SAPA law. After that denial order, this case was then sent back down to the 8th Circuit Court of Appeals, who recently issued their decision in this case. The 8th Circuit sided with the Biden administration and decided that Missouri's SAPA law was in fact invalid. The 8th Circuit believed that this law invalidated federal laws in violation of the Supremacy Clause, and that's why it was struck down. But now Missouri has filed their official petition for Supreme Court review, and they're asking for the Supreme Court to step in and reverse what the lower court said. The Supreme Court will now consider whether or not they're going to grant review to the state's SAPA law case, and now the Trump administration has control back in the hands of, their administration. The AG Pam Bondi and her office are in control of this case, and now once again her office has asked for some additional time to file the reply brief to the Supreme Court in this case. The AG's office has been getting bombarded by the community here for Second Amendment missteps, that she's already been making. So it appears that her office wants to take even more time to consider this case and actually choose the correct path when it comes to this issue of the SAPA law. Now, for those not familiar, in 2021, Missouri passed a law called the Second Amendment Preservation Act. That law set the state's interpretation of the Second Amendment and set restrictions on the support and funding that the state would provide to federal agencies in their attempts to enforce federal laws which violate the Second Amendment. The law prohibits Missouri's officers, agents, and government officials from helping federal agents who are attempting to enforce inconsistent federal laws which violate the Second Amendment. There's also a civil component to this where there's a civil remedy where any resident of the state of Missouri that they could sue a Missouri official if that Missouri official helped to enforce federal laws which violate the Second Amendment. This Missouri law is similar in nature to the Texas abortion law SB 8 and the recent Supreme Court decision in the whole women's health case. With the Texas and Missouri laws and how they're structured, you can't get an umbrella injunction against the state or the attorney general since they aren't actually the ones enforcing the law. Instead, you can get an injunction against the individual who filed the civil suit, but then another civil suit could pop up and you would have to get another injunction, and it goes on and on. In this Missouri case, the district court on review ruled in favor of the Biden administration, striking down the Missouri Preservation Act in its entirety. Now, in response, the state of Missouri then appealed to the 8th Circuit. Missouri also asked for the 8th Circuit to stay the lower court decision while the appeal was taking place. However, the 8th Circuit denied that stay, and that led Missouri for the first time to seek an emergency application and go to the Supreme Court on that emergency basis. On review, the Supreme Court issued an 8-1 order denying that emergency request for the stay. Only Justice Thomas was in favor of granting the emergency stay. Now, after that Supreme Court denial, the case was then back in the hands of the 8th Circuit, and the 8th Circuit reviewed and ultimately ruled in favor of the Biden administration striking down the SAPA law in its entirety. But now Missouri has filed a writ of cert to the Supreme Court on the final merits of the case, so once again, it's back in the hands of the Supreme Court. And now on the other side, instead of the Biden administration, now it is the Trump administration and Pam Bondi who have to decide how they want to respond to this case. Now, in the petition, Missouri presents three main questions for the Supreme Court to answer. First, can federal courts second guess a state's reason for exercising 10th Amendment authority? Second, does the Constitution prohibit states from exercising 10th Amendment authority when motivated by a concern that a federal statute is unconstitutional? And third, is a state official a proper defendant under Ex parte Young simply because the official is regulated by a statute, or does the official also need to possess authority to enforce the law? Missouri goes on to argue in the petition that before this case, it appears no federal court had ever blocked a state from exercising 10th Amendment authority simply because of the reason the state expressed for exercising that authority. The 8th Circuit did that here, striking down a state law solely because the act said that the legislator believes certain federal statutes are unconstitutional. The Eighth Circuit's holding creates multiple circuit splits and is as wrong as it is unprecedented. It declared a Missouri law unconstitutional solely because of the law's legislative findings, specifically the legislator's opinion that some federal statutes are unconstitutional. The court took no issue with what the Missouri law does, only with what the legislative findings actually say. Indeed, the court agreed that a law with the same effect but different findings would be permissible. As the court put it, Missouri may lawfully withhold its assistance from federal law enforcement if it picks a different reason, such as withholding resources as a matter of policy rather than as a matter of constitutional interpretation. Now, one of the things that Missouri is pointing out here in this petition is that the Eighth Circuit essentially said the structure and potential operation of this law is valid, but they ultimately struck it down because the underlying Second Amendment purpose, which was used to create this law. Missouri argues that the Eighth Circuit went against clear precedent and found that state officials could be sued because the court believed the state played some sort of role of enforcement by simply actually complying with the state law. So essentially, the Eighth Circuit said that they believed there was actual enforcement by not enforcing the law. So non-enforcement equated to actual enforcement. I know that seems absurd, but that is what the Eighth Circuit said. Now, this law was opposed by the Biden administration, but now the Trump administration has complete control of the government, obviously, and now has control of the DOJ, the AG's office, and they are the ones who are actually going to be litigating this case and deciding what they want to do going forward in this issue. Now, originally, the federal government was set to file their reply brief to the Supreme Court on February 26th, but they received an extension. This first extension was granted by the Supreme Court, and it put the reply out, essentially to March 28th, so it was due this week, March 28th. But now the federal government, the Pam Bondi and her office are asking for, once again, a new extension. In the recent motion, they state that the petition for writ of cert in the above captioned case was filed on January 23rd, 2025. The response to the petition is now due after one extension on March 28th, 2025. We respectfully request that under Rule 30.4 of the rules of this court, a further extension of time to and including April 11th, 2025, within which to file a response. This extension is necessary because the attorneys with principal responsibilities for preparation of the government's response have been heavily engaged with the press of previously assigned matters. Counsel for petitioners do not oppose the further extension. So the AG's office is now, reviewing all the Biden policies, and they have control of all the prior lawsuits. They are responsible for everything from January 2021 to 2025. Also, they need to review all that under the Trump executive order. And this is one of those significant cases that the Trump administration will now be reviewing, and they essentially want to get this one right. There was a lot of noise after the Peterson Fifth Circuit, suppressor case brief that was filed by the Biden administration holdovers by some of those attorneys. They were still arguing anti-gun policies and saying that suppressors are not arms. And that got, a lot of noise, and, it upset a lot of people. And Pam Bondi and her office in the DOJ got a lot of attention because of that. And so even in that case, they said that they're going to reconsider that they're going to change their position. And then you even had the chief of staff for Pam Bondi state that, Pam Bondi and the AG's office in the DOJ are focused on protecting the Second Amendment, that they want to protect the Second Amendment, that's a high priority for them. And he said to that end, the department will be reevaluating some of its recent litigation positions on Second Amendment issues, including silencers and suppressors. So, this is one of those critical cases that they're reconsidering the position because obviously, at least maybe not obviously, but my hope would be that they have a completely different position than the Biden administration took on the Missouri SAPA law. And so this is one of those cases that's wrapped into that Second Amendment executive order review that they have to come to a conclusion on, that they have to decide what they want to do going forward. And so they're asking once again for an extension of time and trying to push this out even further to actually get this right and maybe not have another huge blunder like what happened in the Peterson silencer case. So we're going to keep our eyes on this to see, does the Supreme Court grant them an extension once again? And if it does, how does the Trump administration and Pam Bondi and her office actually respond to this? What position do they take? What briefs do they actually file? And how do they actually address this going forward at the Supreme Court level? So as we get more information, I will let you guys know. But as always, thank you all for watching. Don't forget to like, comment, and subscribe. And don't forget, this nation was built by armed scholars, and this nation will be maintained by armed scholars.